workshop. It's my pleasure now to introduce our next speaker, our main speaker really, and trainer for this workshop. We're really, really glad and privileged to have with us this morning Paige Berges from Ropes and Gray Law Firm. She is a counsel in the Anti-Corruption and International Risk Group. Excuse me. She is both US and UK qualified. She has broad cross-border experience conducting internal investigations, enforcement, and defense. Her focus is on advising clients with pre-investment due diligence and post-investment monitoring to ensure compliance with economic sanctions, anti-money laundering, counter-terrorist financing, and anti-corruption regulations. So you're in the right place. In addition to the US and UK and pan-European practice, Paige also has significant experience helping clients build compliance programs across Africa, Southeast Asia, and the MENA region as well. She has a strong background in human rights, humanitarian law, public international law, and regularly advises on these issues. She has also long volunteered with and served as a special counsel to Lawyers Without Borders, and she has led on projects with them related to human rights and governance principles and prosecuting human trafficking and corruption cases. So we're really glad to have her today. I'm sure you will benefit greatly from her expertise, as I've outlined in the various areas. So Paige, it's my pleasure to welcome you and to thank you for being with us today. Please go ahead.
Thank you so much, Steph. Really appreciate it. It's great to be here with all of you. So I'm going to share my screen, my slides. And when I do that, I won't be able to see anyone or the chat box. So before I do that, I wanted to say, you know, it's a fairly small group. I know there's questions saved at the end, but I would be happy if anyone wanted to ask questions, pop them in the chat bar. If I'm not able to see Max, if one of the others, you can just flag to me that there's been a question. You know, I don't want you to feel like you have to wait till the end to clarify anything. And also, you know, you're the ones who are looking into doing this, doing investigations and trying to build the evidence to submit the requests for sanctions designations. So I you know, always feel in these situations, I have as much or more to learn from all of you. So hopefully we can draw some of that out either as we go through or at the end when questions come up. But with no further ado, here's the presentation. Okay, can everyone see that?
Yep, I can see that. Great, thank you.
Great, thank you. All right. And so I'm going to go over background of sanctions. I don't know if people have kind of experience with it, but I found it best to normally just do a little bit of scene setting. And then we'll get into the details about what are the factors, you know, what does the UK's anti-corruption regime say? How can you end up on one of the sanctions lists, meeting those criteria? And what are some of the factors that the UK government will consider when reviewing a designation request? So first, sanctions, you know, I think before February, maybe some people could pretend that they'd never heard of sanctions before, but certainly we're all aware now that they are used by governments. They're used by the UN, but they're also used by individual governments like the US, UK, EU, Australia, Singapore, Japan. A lot more governments getting active in the space now to achieve a foreign policy goal. And they take the form of either kind of comprehensive sanctions. Probably the best example is with respect to North Korea. Nearly everything under the sun is prohibited with North Korea, with very few exceptions, or targeted, i.e. list-based sanctions. And that's what we're going to talk about here. That's adding the names of individuals or entities to the sanctions list. The impact being that then anyone subject to the sanctions jurisdiction, so here the UK sanctions jurisdiction cannot provide funds, goods, services to the person on the sanctions list. So it can be quite an impact there. So like I was saying, the prohibition if someone is on a UK sanctions list, is making funds or economic resources available directly or indirectly for the benefit of the designated person. Designated person is the term that the UK and the EU sanctions use, but I may say designated person or sanctioned person kind of interchangeably. Up until February, the EU and the UK lists were largely the same, but now the UK has independent powers to implement list-based designations after Brexit. So this includes both under the latest Russia regime, and then it has their own human rights and corruption sanctions regimes. And so the corruption sanctions regime is what we're going to be talking about today. So the prohibitions apply not only to persons, and by that I mean both individuals, individuals and entities that are actually on the list, but it also includes any corporate entity that's 50% or more owned by that person. And so we'll talk a bit about the end about how to a sort of another way to help achieve accountability for compliance with sanctions. But so companies that fail to apply adequate due diligence, for example, to identify entities 50% or more owned or controlled by a designated person, can also be found in breach of sanctions. And there's also a prohibition on circumvention, which is, really any intentional structuring to try and, kind of technically get around the sanctions prohibition, but actually you kind of know you structured it that way in order to avoid that. So the jurisdiction, like I said, who has to comply with these are UK nationals and legal entities, so companies that are incorporated in the UK, including their branches, although it's important to note that it doesn't include wholly independently incorporated subsidiaries abroad. So, branches, if you think about Barclays Bank, that they have branches abroad, they still need to comply with UK sanctions because of the legal form. Whereas if it's, just a subsidiary, a foreign incorporated subsidiary, they don't necessarily have to comply with UK sanctions. And that's, wherever it takes place. So I'm a UK national because I'm a permanent resident. Wherever I go, I have to comply with UK sanctions. Similarly, if you're not a UK national or entity, but you are undertaking activities within the territory of the UK, you have to comply for that period of time. There's a number of sanctions regimes. Some are the 18 UK sanctions regimes. There we go. I need to flip ahead. The 18 UK sanctions regimes are mostly ported over from the EU, but there are the two independent ones, which I'll talk about. So the Sanctions and Anti-Money Laundering Act of 2018 was put in place really with a view towards Brexit happening imminently, although they didn't know exactly when at that point, to give the UK the power to implement its own sanctions. And so this was both all UN member states have to implement UN sanctions within their domestic law. So that used to happen through the EU. Now the UK has its own power to implement those, very important. But of course, then it gives it powers to implement autonomous sanctions, in particular relevant to Magnitsky style sanctions. And Steph mentioned the Magnitsky style sanctions. And if anyone isn't aware what this means, it refers to, a really tragic incident in the early 2000s in which a tax lawyer in Russia, Sergei Magnitsky, had uncovered, massive fraud and corruption being executed by certain agencies of the Russian government. And, rather than sort of giving up on that, he ended up being imprisoned and ultimately, died as a result of mistreatment while he was in prison. So his, former business partners and client, Bill Browder, has fought since then to get countries to implement these Magnitsky style sanctions programs, which allows governments to add names to the sanctions list when there are either corruption or violations of human rights. So the lists of sanctions are primarily maintained by OFSI, which is the Office of Foreign Sanctions Implementation, which is responsible for enforcement of sanctions in the UK. The FCDO, the Foreign Commonwealth and Development Office, also has a broader sanctions list, which we don't really need to get into, but just in case you kind of ever see it and are wondering, hey, what's happening? And so that includes trade sanctions and transport sanctions. So there are ships and aircraft that are on the sanctions list. Those don't have the same prohibitions on providing funds and services, but those are not permitted to, land or receive other services in the UK. So just the kind of the main list for our purposes is the OFSI list. The global human rights regime was the first independent autonomous sanctions that the UK put into effect. So we're not going to focus on those here, but of course, kind of very similarly to the anti-corruption sanctions, there's an ability for interested groups to build a dossier and to request that certain names are added to the list if they meet the criteria in the human rights regime. And the global anti-corruption sanctions went into effect in April 2021. And these specifically enable designations of persons involved in, quote, serious corruption. This is defined as bribery or misappropriation. One thing to note is it only covers public corruption. So if you're familiar with the UK Bribery Act, you know that the UK Bribery Act prohibits both public and private corruption, right? So it doesn't necessarily have to involve a government official or entity. The sanctions regulations here only cover public corruption, but importantly, it does include the ability to designate persons involved in laundering the proceeds of corruption. So I think that's, that could have a kind of private element to it as well. Currently, there's only 27 individuals on the list, and I'll, pull up a slide with a few examples of what those designations say. But great news to hear that ILP was instrumental in getting 5 names added to the list, so it can happen. One thing I wanted to also mention, and again, when I kind of talk about some of the ways to seek accountability for violations of sanctions, is that the sanctions regime was recently changed to, it hasn't gone into effect yet, but at the moment, breaches of sanctions laws, the government can only find a breach if they can allege that a person had a reasonable cause to suspect that they were dealing with a sanctioned individual. So you can have a defense there if you say, well, look, I did all this due diligence. I didn't know, I had no reason to know, and therefore you wouldn't be liable. They've actually changed that. And when it becomes live, any breaches of sanctions laws will be strict liability. This is already the case in the US. So if you deal with a sanctioned person, if you provide funds and economic benefits to a sanctioned person, you're technically in breach already. So of course you can still raise defenses with respect to the level of penalty that's appropriate, but technically the government already has you. So it's going to be the similar thing within the UK, and there also will be the power to name and shame companies. At the moment, companies' names become public if there's actually an investigation and a finding of breach and a settlement with OFSI. But this power will be naming and shaming just for investigations, even where there's no fine. So this is another sort of new way to think about achieving accountability. So you may be asking, okay, well, what happens when someone's name is added to the sanctions list? Under the anti-corruption regime, basically what it is 2 measures: an asset freeze and a travel ban. So travel ban is you can't come to the UK, and asset freezes is the hook that I was talking about before, which is UK persons firstly, cannot provide funds or economic benefits to the designated person. And if they come into control, if the UK person comes into control of any assets in which that designated person has an interest, then they have to freeze them. So this most often comes up in, you can imagine with banks, it's pretty straightforward. I'm a bank, I receive a fund transfer. I believe that that fund transfer is actually going to go to the benefit of a designated person. I freeze that on my accounts. I don't let it flow into the client account so that the designated person doesn't have access to it. That's a freeze. But of course, technically, any UK person, individual or entity has that requirement to freeze. But, the sort of technical aspects we don't need to get into. All right, so on to the meat of it, the overview of the anti-corruption sanctions regime. So the overarching purpose is to help prevent and combat serious corruption. How's that defined? Corruption is defined as bribery or the misappropriation of property. Bribery, like I said, is only public bribery here, but it's both, so it's giving a financial or other advantage to a foreign public official, so that's the active bribery side. And there's also the passive bribery side, which is the foreign public official receiving a financial or other advantage. And misappropriation of property requires that public official, that official capacity, diverting or allocating public property, right? So property that's entrusted to them as a result of their role, allocating for either their own personal interest or for the interest of a third person. And so this is anything of value. So if they assign contracts to their cousin's company, or they give concessions to their brother's company, then that can be a misappropriation of property. And what are the actual criteria then? So you've got corruption, you've got misappropriation of property. Who's actually then able to be added to the list? Who can you argue should be added to the list? That's anyone who is a quote unquote involved person. And person here, again, it means not just individuals, but it also includes entities, so corporations and organizations of any kind. So involved people are those who are, firstly responsible for the serious corruption or engage in it, those who facilitate or provide support for it, those who profit financially or obtain any benefit from it. So, right, the brother in the concession scenario, those who conceal or disguise it or any proceeds from it. So this is, this can include professional enablers, banks, those who engage in the money laundering side of things, those who are responsible for investigation or prosecution of the conduct, but intentionally or recklessly fail to fulfill that duty. So for example, prosecutors or judges or others within a country who, are sort of, maybe they're not in on it, but they otherwise decide not to prosecute for whatever reason. And so those who transfer or convert any profit or proceeds from it, very similar to the, it's another aspect of money laundering, right? Those who use physical force, threats, or intimidation to interfere in any process of justice. So those who try and help ensure that there's no investigation or prosecution, and this kind of more catch-all of persons who contravene or assist in the contravention of the regulations. So that's a bit of a catch-all. Involved person is not only the actual individual themselves, but it can include any entities owned or controlled who is also involved. It includes third parties who acts on behalf or at the direction of an involved person, or it may be a member of a group. So for example, if it's kind of a political party or some sort of activist group where really everyone in that group is kind of liable, then they can also be deemed to be involved persons. I should note, I mean, with 27 designations, a lot of the scope of this hasn't really been tested, so we're not kind of able to say the full range of where the UK government might go with some of these things, but let's push that envelope, and we'll use all the factors that we have to try and ask for designations. So there is a legal test that has to be met for the person to become designated. So there must be reasonable grounds to suspect that the person is an involved person, right? So you have to demonstrate those factors are met, one or more of those factors is met, and you have to provide the evidence of reasonable grounds to suspect. And secondly, the designation must be considered appropriate. And this is really talking about, well, will it make a difference to them if they're subject to a travel ban or an asset freeze in the UK, right? Because again, UK jurisdiction only applies to UK persons and activities within the UK. If someone's really based purely locally, they don't travel, they don't have assets abroad, then the designation might not really have an effect in practice. And you may think, well, isn't it kind of sending a message? Does that have some benefit? And it may, but also designated persons can challenge their designation. So the UK government is really has to consider very carefully about whether they add names to the lists, because they don't want to end up with legal challenges, and some of which designated people have won, right? And they've gotten themselves removed from sanctions lists, saying that the right, reasonable grounds to suspect and et cetera have not been met. So there's a lot of places to look for guidance too. So I think these slides are going to be available, and I think this is being recorded. I think someone put in the chat, will these be made available? Yes. Okay. So yeah, these slides will be made available, but also there's a lot of guidance just on the UK government's website. So they actually have an information note for NGOs on the type of factors that they'll consider in implementing a designation. And so this is some of that non-exhaustive guidance here. So first, they'll consider the government's anti-corruption policy priorities, which I'll talk about in a bit more detail on the next slide. Next, they'll consider really what's the scale and the impact of the serious corruption? What are the status and connections and activities of the involved person? Is this the kind of scenario where other countries are acting as well? So if the US has designated them, if Canada has designated them, if the EU has designated them or is considering it, then it's more likely as well that the UK will join in. So that's the collective international action piece. Interaction with law enforcement activities is, if someone's already going to be prosecuted within their home jurisdiction or another country that has jurisdiction, then a sanctions designation, may not be appropriate. And they'll also look at risk of reprisals. So is it a scenario where, say, there's a whistleblower or other people on the ground who are kind of the only ones that would know about this activity? Therefore, if the person gets sanctioned, it will be pretty clear to the designated person that, it had to be those people on the ground, and could that cause some impact for them? So that would also be part of the calculus. So this is just going over, well, what are the anti-corruption policy priorities? And again, these are all set out actually on the UK government's website on factors that they look at in designating people involved in serious corruption, right? So is it linked to terrorism, serious organized crime? Does it undermine SDGs, impeding international trade, impeding the rule of law, governance, human rights. So you're getting the sense from this that it really has to be have kind of more of a macro impact on a country, right? So it doesn't have to have a necessarily global impact, but more of a macro impact on a country. And they're not looking to target, sort of more mundane. I mean, look, we all agree that no corruption is mundane. No corruption is unimportant to target. But when it comes to the designations, it needs to sort of have a bigger impact, or that's more likely for the UK government to apply a designation with that impact. And the scale, again, how many people are involved? Is it really systemic? How much value of it? Is it sophisticated? Those sort of considerations. Sorry, my computer's done something weird. The status and connections of the involved person, right? So are they kind of more of a mastermind? Are they really high up? And again, this also goes to the fact of, will the designation have an impact on that person, right? So we're all familiar with politicians whose kids are in school here, who have properties here, who travel here to shop, or family members travel here, and those are also have really large roles within their local, their respective governments. That kind of those kind of factors will make it more likely that a designation is deemed appropriate as well. Here's all the rest of the factors on one slide. Again, collective international action, interaction with law enforcement activities. If law enforcement is pursuing it already, then a designation may not be deemed appropriate, although here the UK government does say it will not automatically rule out designation just because there's a possibility of law enforcement action. So that isn't a dispositive factor, but just among them. And like I said, is there going to be a potential negative impact or reprisals to individuals on the ground? That may also mean that designation's not deemed appropriate. So here's the actual process that you go through. So you submit information to the Foreign Commonwealth and Development Office, the FCDO, concerning possible designation under the anti-corruption sanctions. So they're the overall entity that's responsible for the UK's international sanctions policy, whereas Treasury is the body that's responsible for enforcing for breaches of financial sanctions. So you submit all the information to this email address that's on the slide. You need to ensure that you provide accurate, necessary, and proportionate information. That's from the guidance for NGOs. The government will want to see that, and you should try and demonstrate in the submission that steps have been taken to ensure that the information is verified, or that you can provide a way for the government to verify it from a trusted source, and try not to include ancillary information or information that's not relevant to the proposed designation. The FCDO won't provide comments or updates or feedback, so you shouldn't expect any of that. If you're, they can ask questions though, so you may get more questions, but they won't tell you sort of what's happening, or yes, we're going to add them, or no, we decided not to add that person for XYZ reasons. And like I said, sanctioned persons can challenge their designation. So the easier that you can make the decision for the FCDO, the more you can build out that defensible package of information, really, the better. So what do you include in there, right? So obviously, what is the activity that justifies the application of the sanctions? And make sure that you're tying that description to the activity under the sanctions legislation. So what is it that they're doing, that they have done, that constitutes serious corruption under the regulations? Obviously, who, right? So the name, including any aliases, maybe alternative spellings that may be relevant for the name. What's their position, other identifying information, right? If you know their date of birth, if you know sort of address, or at least city and obviously country where they're located. And again, if it's a corporation, for example, then you may need to provide more information related to the corporate, like when they were incorporated, where's their headquarters, what law they were incorporated under. So just, yeah, have a think about information relevant for the corporate. And, you know, why are they an involved person, right? Did they commit the activity, or are they responsible for moving the funds, or are they responsible for failing to prosecute it, etc.? And this is the bit, you know, obviously the first bit of kind of what is the activity is important, but I think this is really the heart of it in terms of demonstrating there's that reasonable ground to suspect that the person is an involved person. And quite often I deal with license applications to the government, and when clients tend to draft these, I just often find that there's just not enough detail. And you know, here it's kind of, there's no downside to sort of painfully including all detail, right? So don't assume that things will be obvious. Don't assume that terms will be obvious. You know, really just kind of spell everything out to the nth degree. And that's usually the best bet. Because like I said, while they can ask questions, they might not, right? So they may decide, instead of asking questions, we're just gonna put this to the side. So that's always the danger. So there are 27 current anti-corruption sanctions designations. If you wanna look at them, you would go to the OFSI sanctions list, and then the sanctions designations are by regime. So you can just kind of search for anti-corruption, and then you can look there. But I've just put some examples on the slide. So I'm sure far more detail went into the submission request than appears here, but you can look here for some clues over kind of what's the type of activity that the UK has deemed to be appropriate before to designate persons. So, right, so here's an official, so a high-ranking public official, vice president of a state-owned company, so misappropriating public funds, right, by diverting contracts to fake companies or inflated projects. Instead of actually, you know, doing the work for the Nicaraguan state. And similar, so a deputy and vice president of and board of the directors of the Congress of Guatemala. So using position to attract clients with the offer of expediting the refund of tax credits. So therefore really depriving the state of tax resources and benefiting from bribes. So I included one here, which is related to Russia. I did just want to say that there are quite a lot of people, especially recently, but including since 2014, who have been added to sanctions lists for kind of corruption-related reasons, but this has actually been under country-specific sanctions regime. So, for example, in the current Russia sanctions regime, there's really kind of broad designation power, so that people engaged in corruption can be added to the list, but under the Russia sanctions regime and not necessarily under the anti-corruption sanctions regime, which should maybe give us comfort too, that it's not just 27 people who have been designated for corruption, but it's just, at least with some programs, there are people who just kind of end up under the country specific program rather than the anti-corruption sanctions. And so talking a little bit about confidentiality considerations. So the FCDO does say in its guidance that if you mark information as confidential, I mean, it will treat the information as confidential in any event, but if you specifically mark it as confidential, they will take extra steps to keep it confidential, to protect the identities of non-involved persons who are named or who are involved in submitting the designation request. But you should be aware that some information may end up being made public. So for example, there's going to be information that ends up in the actual designation listing itself. They may need to speak to other departments of the UK government, you know, maybe law enforcement, to maybe get some more information. Maybe they want to ask UK companies who they think may be dealing with a person for more information. So there's always kind of that risk to be aware of, particularly if you need to protect identities of sources, of journalists, et cetera, or your own identities as well, depending on the context. There's also freedom of information requests, or if there's litigation, if someone challenges their designation, for example, then they would have, you know, they may be entitled to request some of the underlying information and documentation that you submit. So it's just something to consider if you have those kind of confidentiality or security concerns, and if there's any way to submit the request without, you know, causing a kind of undue concern about that. So I mentioned earlier that I did want to talk about alternative ways to seek accountability for sanctions breaches. And so there's this aspect of course, getting names on the sanctions lists, and you know, that's good. We've covered that. But what do you do if actually you think a UK company or UK person is breaching sanctions, is continuing to provide services to someone who is listed on a sanctions list? Well, you can actually now report suspected violations of financial sanctions in a couple of ways. So the first one is if it's just an individual or entity that's not a financial institution, although you can also report them if they are a financial institution, but to the Office of Financial Sanctions Implementation, which I said is the enforcement body for asset freeze sanctions. And how do you do this? There's a compliance reporting form on the website. There's sort of 3 potential violations. So first, you can report if you suspect that someone is actually a designated person. So let's say you've got, you know, ABC Trust Limited that's been incorporated in the UK, and you think, okay, actually they're owned by a designated person. You can report that, right? And you can get that, hopefully get that name added to the sanctions list as well. You can report information on frozen assets. So that's more if you have assets on your own books, or, you know, if a UK entity has had to freeze assets that it has control over. And then the final category, right, is where you have information on suspected breach. So if you think, I don't want to say lawyer because that's putting my own profession in trouble, but if you think, you know, let's say a fintech company is continuing to provide financial services to a designated person, you can say, hey, look, this company is still lets him, you know, this guy have accounts, lets him process payments, and, you know, you should really shut that down. So those are kind of 2 other ways to achieve accountability. so you send the compliance reporting form to that email, or you can also post it, which I suppose you may want to do if you want to keep things confidential. Again, you wouldn't expect to get, you could get questions back, but you wouldn't expect to get feedback on what they're doing with the information, whether they're investigating, etc. I mentioned financial institutions. While you could report them to OFSI, there's also a way. Financial institutions are regulated by the Financial Conduct Authority in the UK, and they may have a bit more capacity than OFSI. So if it's a financial institution that's regulated by the FCA, you may want to report through the FCA's sanctions reporting mechanism. And so the details on this is found on their website. And this is an interesting mechanism, because it's not only if you suspect a breach, but you can also just report if you think a company's doing, or a financial institution's doing a really bad job of detecting sanctions individuals or sanctioned activity. And that's because the FCA requires regulated firms to have adequate systems and controls. So for example, if they don't have the right compliance program, they can be in breach of FCA regulations. So similarly here, if you just think a regulated financial institution is, just doesn't have the right screening, due diligence, approvals process, whatever it is, in place to actually ensure that they're not supporting sanctioned persons, then they can also be reported to the FCA through this mechanism. Here's some of the details about what you want to include in that, and this is all on the FCA's website as well. And including here just an example of an OFSI penalty. This actually originated from a compliance reporting form filed by a third party. So a third party said, look, we think that they've breached. TransferGo Limited has continued to allow customers to send payments to sanctioned persons and sanctioned countries. You should have a look. And as it turns out, then OFSI actually did impose a fine against them for that breach. So it can work. So I think I've just made it to the mark to leave time, half an hour for questions.